discussing special contracts. So we started discussing special contracts the last month. So we covered almost all uh, the contract of guarantee, contract of indemnity, contract of bailment, pledge. So now we are at this topic, contract of agency. So contract of agency, uh, how we can define, how we can explain. So if you go to section 192, so this is which chapter of Contract Act? Appointment and authority. So since we don't have much time, uh, I'm not waiting for your answers, but still in between, if you have, whenever I'm asking questions, if you have any reply, kindly open your mic and say. So I always welcome that. I don't have any problem for that. So section 182 to 238. So this is a part where we can see the contract of agency explained. So contract of agency. So different types of contracts, specific contracts we already learned. The contract of agency is one of the special kind of contract. You know, all of you or most of you have already covered contract or loss of contracts, and you know contract of agency also well. So contract of agency, I don't think that I need to explain the concept, the definition of contract of agency that is there under section 182, where where agent and principal are different. You can see section 182. An agent is a person employed to do any act for another or to represent another in dealings with third persons. Somebody is going to represent another. So going to represent another, or you are going to represent me on behalf of me before another person. So third person before another person, somebody else is representing. So the person for whom such act is done, or who is so presented, is called the principal. So if you are representing me, means I am the principal, you are the agent. Or if I am representing you, that means you are the principal, I am the agent before a third person. So from there itself, from the section 182 itself, we can identify the essential requirements of contract of agency. So contract of agency, mainly the parties, that is principal, agent, and definitely this should be before third person or a third party. And one person is representing the other. Take the ingredients from the section itself. So section 182 says the agent is a person employed to do any act. So it can be any act for another or to represent another in dealings with third person. So employed to do any act or to represent, two things: employed to do any act or to represent another in dealings with a third person. So for I want to deal with a third person, I want to deal with someone, I want to enter into a contract with a particular company, but I'm not available to enter into a contract with them. So I'm assigning you, or I'm assigning somebody else to represent me before them, to sign off the contract, or to discuss with them, or to execute the contract, or so whatever it is. So you are going to represent me before the other company. So this is what the contract of agencies. This is something we all know well. So as I already said, Chapter 10 of Indian Contract Act is dealing with concept of agency. So since you all know the concept of agency, what are the important points we need to see? So let us see the Bear Act, the sections, how it is arranged. So what are the different points we have to see in a competitive exam point of view? So that is what we are trying to do here, right? So when we come to section 182 to 238, so this is the last part of the enacted Contract Act, right? So this is the last part. 182 to 238 means around or less than 50 sections. So more than 40 sections we can say, right? Section 232 to 1 to 238, the last chapter. So we can see the sections are arranged like this. So these are the points which I have taken from the Barracks as well as from Pollock's book. So when we discuss or when we see the rights and duties of agents, we cannot say that it is given in that order as we can see in the other kinds of contracts. So ഇവിടെ നമുക്ക് ഇൻ ബിറ്റ്വീൻ അങ്ങോട്ടും ഇങ്ങോട്ടും ഒക്കെ പല സെക്ഷനുകളിലായിട്ട് റൈറ്റ്സും പല സെക്ഷനുകളിലായിട്ട് ഡ്യൂട്ടീസും കിടക്കുന്നതൊക്കെ നമുക്ക് കാണാൻ പറ്റും. അപ്പൊ ഒരു കണ്ടിന്യൂസ് ഓർഡറിൽ സാധാരണ ഭാഗത്ത് പറയുന്നത് പോലെ തന്നെ ഇവിടെ പറയുന്നു എന്നൊന്നും പറയാൻ പറ്റത്തില്ല. ഇടയ്ക്ക് ഡ്യൂട്ടീസ് നമുക്ക് പല സെക്ഷനുകൾ അപ്പുറത്തു നിന്നും ഇപ്പുറത്തു നിന്നും ഒക്കെ എടുക്കേണ്ടതായിട്ട് വരും. സോ എങ്കിലും ഒരു അറേഞ്ച്മെന്റ്, how we can arrange it, is how we can like divide this chapter. So 182 to 185, it is the appointment of agents. So 182 to 185, 182 definition, that is something we know. The essential ingredients of section 182, you must remember, you must point this, take note of that. What are the important points of an agency? So if you are given with a situation to understand whether this is a contract of agency or whether this is a contract of partnership or whether this is a contract of bailment, if that is the question, or if the question is in such a nature, you should identify what are the essential features. So section 182 says three things mainly. That is, one is a person is employed or he is represented by another before a third person. So these characters should satisfy there in the situation where we are going to examine. So appointment of agent, section 182 to 185. 182 definition, 183 who may employ agent. So kindly go through your Bear Act, see that. So this is something very much essential for us to see the Bear Act and identify the scheme of this chapter is. So if we understood that, that itself is enough for us to understand or prepare for an exam. So because we already know the concept, so we know, I don't think that any one of you require me to explain you what does it mean by agency or what are the different types of agency. That is not what we are expecting, and that is what you are I know that is not what you are also expecting. So let us see the sections, how it is being arranged and what are the important points we can, and in the competitive exams point of view. So section 182 to 185, that is appointment of agency. So who may employ an agent? So who can employ? Who may employ an agent? So that is what section 183 is. Who may be an agent? Who can be an agent? So there we know the important point is with regard to the minor. Minor can be an agent, right? But minor, like as between the principal and third persons, and any person may become an agent who is not of the age of majority and of sound mind can become an agent so as to be responsible to his principal according to the conditions in that we have here in. So minor is can minor be an agent or not? You tell me. Whether minor can be an agent or not. You already learned this, right? So how the section? Yes, Pravina.
No, a minor cannot be an agent.
Yeah, so as to be responsible. So minor, even if he becomes an agent, he cannot be responsible for the liabilities of an agent. So as between the principal and third persons, any person become an agent, but no person who is not of the age majority. and of sound mind can become an agent so as to be responsible to his principal according to the provisions in that behalf here in contained. So the principal will be having the complete responsibility if that is the case. So if it's not of an age of majority and sound mind. So just go through the titles of the sections and important points, and we will discuss in detail like wherever it is required, considering our limited time. So minor is an important factor which we need to see and understand when we discuss the concept of agency. Whether minor can be an agent, if minor can be an agent, then whether he will be responsible, whether minor can employ an agent, any person who is of the age of majority according to the law to which he is subject and who is of sound mind may employ an agent. So that's how the sections are arranged. So section 182, 183, 184, then 185. So the consideration is not necessary. So no consideration is necessary to create an agent. That doesn't mean that without consideration or the agent can be with consideration or not. It can be with consideration also, but it is not necessary. An agency, an agent can be agency can be created with consideration or without consideration, as gratuitous or non-gratuitous. We see the same kind of concept in the case of bailment also, right? Contract of bailment also, the same thing is what we can see. So it can be a gratuitous bailment or non-gratuitous bailment. Here also, the consideration not necessary. So no necessary, no consideration is necessary to create an agency. Then 186 to 189, authority of an agent. So what is this authority? So here we have to see if you differentiate between few other relationships. So if you take partners, servants. So just see what is the authority of a wife to represent for his husband. What is the authority of a partner to represent his firm? What is the authority of an employee to represent his employer? These are the different points which we can see as important here. Authority of an agent. So authority of an agent. So see, we know as per the Partnership Act itself, what is it? Whether a partner is an agent, is partner an agent or not? Partner is an agent of his firm, right? So whatever things he is doing, he is acting as an agent of the partnership firm, right? So this is there under as per the Partnership Act itself. So agency can be created in different forms. That is what we are studying in one of the slides which we have given here, and also one of the topics which we have seen. So by operation of law, as per operation of law, certain agencies are being created. So one is actually partnership. Similarly, different other situations can be. So we know when we come to Companies Act and all, shareholders or managers or other concepts, other positions of the companies can become an agent of the other. There will be a kind of relationship between them. One person can represent the other. It can be. So certain situations it can, by operation of law, it can be created. So I'm trying to relate it with the other things also when we discuss one. So section 185, 186 we saw. So employee, what is between an employee and agent? So if we are given with a situation, an illustration is given, in that we are asked to identify whether this is an employment or whether this is an agency, how we can understand, how we can differentiate this. How we can differentiate it. If it is an employment, what will be the difference from an agency? Whether an employee can apply his discretionary power to do the things. So for a particular matter, he with certain matter to be done. he is asked to represent his principal, or that is one case. That is a case of contract of agency. On the other side, suppose a person is employing another, definitely the employee will be under the complete discretionary power of the employer, right? Employee won't be having any discretionary power to decide on things, how to be done, how it has to be done, or how it has to be uh, executed. But in the case of contract of agency, it is not like that. An agent can apply his discretionary power certain situations. So agent is assigned with certain things, but he has. So when we analyze the rights and duties of the agent, we can see that, right? So the agent, he has the responsibility to do certain things. The duties, a list of duties of agent that itself represents this, that itself explains all these things. See, duties. So the agent, being an agent, he has to protect and preserve the interest of the principal. Section 209. Just see these sections and connect it with the concept we are studying. So why these are all? That is what I am trying to explain. Instead of giving you like one by one rights, what are duties, I can go like that also. Instead of that, I believe this would be helpful if you are preparing for a competitive exam. So why this is? So how an employee and an agent is different, because agent is having lot of other responsibilities, not as like an employee, right? So agent is appointed for certain things, but he has certain responsibilities to fulfill this. He has a responsibility to protect the interest of his principal. So why it is, again, come to the sections, come to law. Many of these sections are explaining this. Section says that agent is having right to a responsibility to protect the interest of his principal. So see, section 209, where or you see from starting from section 211, agent's duties to his principal. So agent's duty in conducting principal's business. So it need not and everything principal must have explained to the agent. Agent ഓരോ കാര്യങ്ങളും പ്രിൻസിപ്പൽ ഓരോ കാര്യങ്ങളും ഏജന്റിനോട് പറഞ്ഞു കൊടുത്തിരിക്കണം നിർബന്ധമൊന്നുമില്ല. Agent has to take responsibility and fulfill it. പ്രിൻസിപ്പൾ ഏജന്റിനെ ഒരു വർക്ക് ഏൽപ്പിച്ചിട്ട് പോയി, അല്ലെങ്കിൽ ഒരു ബിസിനസ് ഏൽപ്പിച്ചിട്ട് പോയി, agent has the responsibility to manage it properly so as to not affect this adversely to the principal. പ്രിൻസിപ്പലിനും ദോഷം വരുത്താത്ത രീതിയിൽ അതിനെ മാനേജ് ചെയ്ത് കൊണ്ടുപോകാന്നുള്ളത് ഏജന്റിന്റെ ഉത്തരവാദിത്തമാണ്. പക്ഷെ ഒരു എംപ്ലോയെ സംബന്ധിച്ചിടത്തോളം അങ്ങനെയല്ല. അയാള് എംപ്ലോയർ എന്താണ് അയാളെ ഏൽപ്പിച്ചിരിക്കുന്നത്, അതാണ് അയാൾ ഫുൾഫിൽ ചെയ്യേണ്ടത്. റൈറ്റ്. സെക്ഷൻ 209 is what so duty on termination of agency by principal's death or insanity. So similarly, section 211, duty to execute mandate under section, duty to act with care and skill. So he has to apply his normal prudence and do the things. Skill and diligence required from an agent, section 212. And other responsibilities, other criteria are there. So that is so that is why I was telling you like how this is distinct from the concept of employment. So that can be a question in the kind of exams we are appearing for. So we were discussing sections 182 to 185. We saw that. So 186 and to 189, authority of an agent. So in authority of an agent, so 186, agent may be expressed. Agent's authority may be expressed or implied. Need not be always expressed form. It can be an implied form also. Express definition of expressed and implied authority. Authority is said to be expressed when it is given by words or spoken. You know that. I don't need to explain it. So that is section 187. So section 188. Extent of agent's authority. So what is extent of authority? An agent having an authority to do an act, to do every lawful thing which is necessary in order to do such act. So this is something we can by heart. ഈ ഒരു സെക്ഷൻ വളരെ ഇമ്പോർട്ടൻ്റ് ആണ്, and that is something we have by heart. How the section is explained. See, what is the extent of agent's authority? നമ്മൾ നമ്മുടെ വേർഡ്സിന് അതിനെ എക്സ്പ്ലെയിൻ ചെയ്യാൻ പോകുന്നതിലും ബെറ്റർ ആ ഒരു സെക്ഷനെ അതിനെ അതുപോലെ തന്നെ ഇങ്ങ് എടുക്കുന്നതാണ് അല്ലേ. So an agent having an authority to do an act has authority to do every lawful thing which is necessary in order to do such act. Principalന്റെ ഇൻട്രസ്റ്റ് പ്രൊട്ടക്ട് ചെയ്യാൻ what all things he require, all those things are lawful ആയിട്ടുള്ള is something he has to do, whichever is necessary in order to protect his principal's interest, in order to do that act. The extent of agent's authority. An agent having an authority to carry on business as authority every lawful thing necessary for the purpose or usually done in the course of conducting such business. An agent having authority to carry on a business has authority to do every lawful thing necessary for the purpose of. Purpose, not of is not there, of is afterwards only it is given. So purpose or usually done in the course of conducting such business. Each and everything is having its own meaning. For the purpose. So what does it mean by that purpose? You can see illustrations given there, and also try to read any commentaries where it is explaining what is a purpose usually done in the course of business. So all these things we can see in the illustrations itself. So I was appointed as an agent to manage a particular business. So the business, usually we used to take certain goods supplied by a particular supplier. Similarly, the business is doing this. So when I was also appointed as the agent, I was also doing the same thing. This is something usually done in the course of business. So tomorrow, if principal says what I did is not as per the contract, that cannot be agreed. As per the normal course of business, right? Whatever I did was as part of the normal course of business, right? So that is what the normal or usually done in the course of business. So applying or explaining that facts, however it is given, we have to ascertain whether the agent was acting in the course of business or whether this is something he did as not as part of course of business, but he was doing something outside the purview of this normal business or ordinary business. So then that will be out of the purview of contract of agency. What he did is something but it was not. So again, നമ്മൾ ഇനി അങ്ങനെ പോകുമ്പോഴത്തേക്കിനും within contract, within principal agent relationship അയാൾ ചെയ്തതും ചെയ്യാത്തതും പറയുമ്പോഴത്തേക്കിന് again that has different consequences. Within the contract, then principal has liability. Without the contract, or if it is outside the contract, again it will be having different consequences. Again, that is another important area we have to see. That is something we can see from the or on the in the coming clauses, in the coming sections we can see that revocation, renunciation. So after that, principal's duties towards the agent, section 220 to 225. That is the area where we can see the effect of contract with third persons. So those all sections are going to explain this. So whether the person, the agent who was appointed to do certain things, he did it, whether it was in the normal course of business he did it, or he did something outside the purview of the contract, then how or what are the consequences of such kind of contracts or such kind of acts? Whether the principal will be liable, or whether the agent will be liable, or how a bona fide third party, a third party who was not aware of these kind of things, or because he was not aware, he was expecting that the agent was representing the principal, or like whatever the consequences, whatever the situations is. So how this will be affecting. So that is what we can see from the further sections. So here section 186 to 109, where we can see an authority of an, so extent of authority, as I told you, section 180 is something you need to take the entire section by heart. It mainly lawful thing which is necessary to do such a, underline it, study it well, for the purpose or usually done in the course of business. So what is the extent of agent's authority is something important. Agent's authority in an emergency. So again, that is what section 189 is. Agent's authority in an emergency. This is also one of the factors which differentiate an agent from an employee. So here an agent is having right or authority in the case of an emergency. So he is different from, or his powers, his rights, his duties are different from an employee. He's not an employee, he's an agent. So here we can see the authority in the situation of an emergency. So here 189 is explaining the emergency situation where will be getting authority. So section 189 explains like this: an agent has authority in an emergency to do all such acts for the purpose of protecting his principal from loss, as would be done by a person of ordinary prudence in his own under similar circumstances. നല്ലൊരു illustration അവിടെ നിന്ന് തന്നെ നോക്കിയാൽ, so you go to the illustration. It consigns provisions to be at Calcutta with directions to immediately to see at Cuttack. So A consigns provisions to be at Calcutta with directions to send them immediately to see at Cuttack. B may send provisions at Calcutta if they will not bear the journey to Cuttack without spoiling. So something he must have done immediately without waiting for the instruction of the principal, whether an agent can do or not. So that is a question. So I am assigned with certain things. Immediately there is a requirement. So then we have to do certain things. We cannot claim the authority of emergency at any point of time. If we are trying to claim the authority of emergency, then there must be a necessity and something which we are doing. We were not able to take the response of the principal immediately. We were not able to communicate it with the principal immediately. So if we are waiting for that much time, the response from the principal, then for loss. So to avoid such a loss, so these all things agent has to prove. Agent has to prove that there was no such situation. There was no time to communicate the matter to the principal. So if we see the different kinds of formation of contract of agency, creation of contract of agency. So creation of contract of agency, we can say expressly or impliedly contracts are being created. So impliedly created contract itself, when we take, in that there are different categories. I hope you can see our slides here. So agency by necessity. Section 189 is a situation where agency by necessity can happen. I hope no other sections are explaining this. So section 189 is where we can see this agency by necessity. An agent's authority in an emergency. An agent has authority in an emergency to do such all acts for the purpose of protecting his principal from loss as would be done by a coarse person of ordinary prudence in his own case under similar circumstances. That is agency by necessity. Then agency by estoppel. Section 237 is where we can see agency by estoppel. So the concept of estoppel, you know. So because you are not denying the other person is acting as the fact that other person is acting as agent and he is representing. So we both, you are having a car, or you are having a car, and we were standing together. I am explaining to another person as this is my car, or I am representing you as an agent, and I am ready to sell this car on behalf of you. You are not denying this. Can form into the kind of an estoppel, and impliedly you are applying, impliedly you are accepting a creation of a contract of agency there. Can create a kind of section, a kind of contract of agency by estoppel. That is section 237. You see, liability of principal inducing belief that agents' unauthorized acts were authorized. I was not authorized to do this, but because you were silent, this was reflected reflected before another person, a third person, that I am your agent. So now you have created, you induce such a belief in the third person's mind that I am your agent. So now you are not allowed to deny whatever you have accepted, whatever you have, like whatever belief you have created, and the other person must have acted also. So if you are not now trying to deny the fact, now trying to deny the belief which you have created, then the other person may suffer. So in such situations, it is considered as an estoppel, and a agency by estoppel. We know the meaning of the word estoppel, right? He stopped to deny back whatever he has already agreed, whatever he has already admitted, or something impliedly he has accepted. So now he cannot deny it. See, he has already accepted. And the next concept is holding up. This is also an implied kind of contract of agency. I don't know whether many books are explaining the concept of holding out as a form of creating an agency. If any of you have read it, would be better. I think students who has attended last day's legal assistant of secretariat test, they must have come across a question like this, isn't it? Everybody attended it, relating to holding out. There was a question, isn't it? Anyone? Many of you have attended, right? ഇന്നലെ നമ്മുടെ ലീഗൽ അസിസ്റ്റന്റിന്റെ ടെസ്റ്റ് ഇല്ലായിരുന്നോ? ഇന്നലെ അല്ലേ? ഇന്നലെ, റൈറ്റ്? അപ്പോൾ നിങ്ങൾ അറ്റൻഡ് ചെയ്യാൻ പോകുന്നേ ഉള്ളൂ. ചിലർക്കൊക്കെ ഇന്നലെ ഉണ്ടായിരുന്നല്ലോ, ഇല്ലേ? ഒരു ടെസ്റ്റ് അല്ല, ഒരു ക്വസ്റ്റ്യൻ ഉണ്ടായിരുന്നോ ഹോൾഡിംഗ് ഔട്ടുമായിട്ട് ബന്ധപ്പെട്ട്? എനിവേ, ആരോ പറയാൻ വരുന്നു. യെസ്. Okay, anyway, so the concept of holding out is, suppose yesterday what question it was there, I didn't see the answer key. Anyway, the question, so that's why I just thought that to discuss with you. So ഒരു partnership firm. So what happens? Our partners are agents, right? So what happened is this partner, so suppose two partners were there. So this partnership was continuing. One partner has retired from that, but he didn't make any public notice of this retirement. Shruti Vijayan, can you? Yeah. Apom, partnership firm, one partner has retired from the partnership. Fine, but the partnership is continuing because another partner has joined. So the partnership was continuing. And the retired partner, he didn't make any public notice. So you must have learned Partnership Act. So as per Partnership Act, we know a retiring partner must make a public notice. Until that, his authority or his responsibilities will be sustaining there, right? So before that person, he is still representing the company or the firm, not company, the firm, right? So here, what happened is this person he didn't make any retired partner. He didn't make any public notice. Fine. So he, before third persons, before the public, this person is still acting as one of the partners of the firm. So a third party or one of the parties who agreed by the activities of the firm actually saying the retired partner is not part of the firm, but he didn't make any public notice. So before third person, before public, this is also a person. Retired person is also part of the firm. And he filed, suppose it is Izzard, he is the person aggrieved by the activities of the firm. Izzard filed a case making all these persons liable. All the three persons, retired partner, existing partner, and the new partner, all of them liable. He filed a suit. Izzard filed a suit against all these persons together. What will be your reply? Whether this case can be maintained or not. The question was like that. Somebody who knows about this question a little more perfect way, they can explain it. This is what I remember. So answers where the options were given, whether the suit is maintainable, whether the suit is not maintainable, then so and so. 2-3 other options were there. What is your reply? So the concept of holding out is this. Even though he has already terminated the contract of agency, or even if it is in the case of partnership, the concept of holding out is this. Something which is still holding. Already actually saying in July he has already out firm. He is not still continuing with the firm or with the principal. So suppose if it is the principal's case, principal and agent case, agent has already been terminated. But before third persons, this is not aware. Another person is not aware about it. That person whom this agent was dealing with, he is not aware of it. And he is still acting as, or before other persons, this he is still behaving as like an agent of the principal. Or in the case of partnership firm, as I explained in the question which I told you. The retired partner is still acting as one of the partners of the firm, or because there was no public notice made, it is reflected before others that still he is continuing. This is what is called as holding out. So he will be responsible. If you have a different, I'm ready to hear to that. But this is what I can see from that particular question. So this was a question. It was there in the legal assistance test, which was held on Friday. So agency, so the holding out concept is not something very big, but these kinds of concepts can be asked as a question in competitive exams. So always remember this. The contract of agency created by holding out. So it can happen. So it is already, the person is already give up his power as an agent, but still he being considered as responsible because of agency by holding it. This is not a concept which is usually explained in our but this is a concept very important since we saw these are coming in competitive exams. An agency by operation of law, as I told you, by operation of law, by legal provisions, some kind of agency is created. That's all. So this can happen as per any law, as Partnership Act. I think the holding out section I have included. Yeah, here it is. This is section 28 of Indian Partnership Act. Anyone by word spoken or written or by represents himself or knowingly himself to be represented to be a partner in a firm. So this is explained in the context of Partnership Act. That's why it is saying that partner. But remember how partner becomes an agent. That you know, right? So is liable. Section 236 of Sigma Das is saying section 236. 236 is, what is it there? and forcibly contracting an agent not entitled to performance. The person with whom a contract has been ended. Can you tell me, please, what you are trying to say?
Sir, it's like whenever an agent should acting for himself, then he is liable for others. So section 236 that is about the person falsely contracting as agent not entitled to perform. But he is whether he is liable or not, that I think he is liable. Can be say that holding out. എനിക്ക് correct ആയിട്ട് അറിയില്ല sir. അത് തന്നെയാണോ?
Concept note ചെയ്യാൻ വേണ്ടിട്ടല്ലേ പറഞ്ഞത്? Fine. Person with whom a contract has been entered into in the character of agent not entitled to require the performance of it. If he was in reality acting not as agent but on his own account. So again, this is contributing to the concept of holding out. So this particular section of Partnership Act is also holding out concept is explaining. So why I am again and again stressing holding out is because of this what we saw in the last exam. So is liable as a partner in the firm to anyone who has on the faith of such representation given credit to the firm, whether the person representing himself or represented to be a partner does or does not know the representation has reached the person so giving credit. So contract created by different forms of by expressly, impliedly. In the case of impliedly itself, you remember, so expressly by way of contract is created. By impliedly, different forms it can. So all these other forms not expressed, they are all implied form of contract, no doubt, right? So here we are taking subcategories by necessity, by estoppel. Under the concept of estoppel itself is what holding out. Estoppel is something like holding out is something explained under the concept of estoppel. So holding out is also one is important here. Then agency by operation of law, as I told you, by legal provisions, agency is being created. By ratification, and there was no agency at the time of commission of the act. Agency was not there, but later it was accepted. So for this also there are certain conditions to be satisfied. That is coming under section 196 to 200. Let me see whether the points are covered. Sub-agent, let it be there. Before that, let us go to the other things. So by ratification also we will see, then further we will come back to sub-agent and substituted agent. Fine. So section 196 and 200. In between this, Q facet per alium facet per se, which means he acts through another, does so for himself. Those things I don't think that I need to explain it. What are the limit of authority? Specific agent, general agent, universal agent. General agent and universal agent means what? So universal agent and general agent, how it can be different? Anybody? So general agent, specific agent for a particular general agent in a larger point of view. Universal agent is not totally for all things what he wants to do. Everything is assigned to some. Then on the basis of nature of act or business. So based upon the nature of business is what? Mercantile, factor, intermediary, commission agent, credence agent. Credence agents, I quoted an explanation here, so I will explain you that. Non-mercantile agents, it can be different forms. Agent means an agent employed to sell goods and who under purchasers he procures will pay for goods they take. In case they do not pay, he indemnifies the principal for the loss. So he take extra commission for bearing the risk, but he has no personal responsibility. So the cadre is not liable to the buyer for any default on the part of the principal. That is what del cadre agent. Rights and agents, I don't think that I need to know it well. So come to the ratification. So ratification, section 196 to 200. come to section 196 to 200. Express or implied ratification can be the knowledge requisite for valid ratification. So no valid ratification can be made by a person whose knowledge of the facts of the case is materially defective. So it should not be something hidden or something misrepresented and asking. So there are case laws, number of case laws are there where we can see the ratification because of representation. It was misrepresented to the principal and getting ratification. That should not be done. If that is the way it has been accepted, then that is not a kind of ratification. So effect of ratifying unauthorized act forming part of a transaction. So something it was already assigned. He did something unauthorized also, but it was later ratified. Section 199. 200 is something very much important. That is also again an important section, as I told you before. Here also important factor with regard to creation of contingency. So there can be a question like an illustration can be given so that the person is affecting the interest of another or causing an injury to the right of another. So suppose he is terminating a lease or something, some way of, so there was adequate period of time, proper lease was there. One person is affecting the interest of the another, terminating that lease and later getting it ratified. Actually, there's an agent who did the act, who terminated the lease. He was not having authority to terminate the lease. Suppose that is a situation. So lessee's rights which were terminated by the agent, but this agent is not having any authority to do that. Later he is ratifying this, whether this can be possible or not. So here 200 says, so there are illustrations also here without proper notice A. So you see illustration B of section 200, very important. Mark it, study it. This can be, or this is a kind of question you can see in competitive exams. So what it is given, what it is said here, an act done by one person on behalf of another without such person's authority, which if done with authority, would have the effect of subjecting a person to damages or creating any right or interest of a third person. Cannot by ratification lead to such have effect, to have such effect. So a ratification cannot be made so as to affect the interest of another person. So such a kind of, as I illustration. So in the case, so this is something important. Section 200, you mark it and study it well. Section 200, ratification. In what kind of situations ratifications cannot be made? And in the case of ratification, how this will be effective? So a ratification, when it will be considered as effective from the time of from the time of commission of that act. So it will be considered as effective from that point of time. Okay. So ratification of unauthorized act cannot injure third person, and its illustration also kindly make note of. So ratification this is called as ratification doctrine of relation back. Kindly note this point also. Maybe you can write it near to your bare act, or if you are making a note, then you put it there or write it there. Doctrine of relation back. That means ratification relates back to the date on which the agent first contracted. Ratification. We can go to sub-agent. Then we will come to duties and rights. So sub-agent, section 192, 195 is where we can see sub-agent, substituted agent. These are the two things. So an agent is appointed. whether he can appoint another person also as an agent, his agent, whether he can substitute his agency. These are the things which we can see here in the section 192, 195. So subagent 191, subagent defined. You know that one person employed by acting under the control of another. An agent is appointing another person as an agent, so that is subagent. So here, what is important? Whether the principal will be liable or not. So that is what now privity will be. No privity will be subsisting between subagent and a principal agent. But substituted agent, it will, because in the case of substituted agent, what is happening? The agent will be going out, and a new person will be appointed as the substituted agent, right? So subagent, an agent, person employed by and acting under the control of the original agent in the business of the agency. Suppose it is a construction of a building. One person is constructing and he is giving an agency. He is appointing another person as an agent of him to complete certain acts. So representation of principal by subagent properly appointed. So what does it mean by this properly appointed? So agent's responsibility of subagent and subagent's responsibility. Two parts are also there for section 192. So section 192, where a subagent is properly appointed, the principal is, so far as regards third persons, represented by the subagent and is bound by and responsible for his acts as if were an agent originally appointed by the principal. What does it mean by? So that subagent will be representing before third persons as he has been already appointed by the principal. Agent's responsibility for subagent. The agent is responsible to the principal for the acts of the subagent. So the agent will be responsible for the acts of the subagent. Then subagent is about. The subagent is responsible for his acts to the agent, but not to the principal. So if he wants to get something, he has to get it from the agent, not the principal. Except in case of fraud or willful wrong. But if there was a kind of fraud or willful wrong, then definitely the principal will be responsible. Then the principal can ask for. Then the principal can ask the subagent to report to him. So the plumbing works, the electrical works, if that is something the contractor has assigned to somebody else, he is responsible to the contractor only, not to the owner of the building. But if there was a kind of fraud, some kind of fraudulent act was committed or willful wrong was committed, then the owner can directly ask it to the plumber or the electrician who was doing such kind of activities. Section 194, section 193 is where responsibility for subagent appointed. So the first sections, they are explaining with authority. There is a possibility of appointing a subagent. That is something already been recognized by the principal. But if it is somebody appointed without the authority of the principal or given by the principal, so then what will be the consequence of it? Section 193, agent's responsibility for subagent appointed without authority. When an agent, without having authority to do so, has appointed a person, so underline, without authority to do so, has appointed a person to act as an agent, subagent, to act as a subagent, the agent stands towards such person in the relation of a principal to an agent. So agent stands towards such person in the relation of a principal to an agent and is responsible for his acts both to the principal and to third persons. The principal is not represented by or responsible for the acts of the person so employed, nor is that person responsible to the principal. So where an agent, without having authority to do so, has appointed a person to act as a sub-agent, the agent stands towards such person in the relation of a principal to an agent, and is responsible for his acts both to the principal and to third persons. So if a sub-agent is appointed without authority, so then where an agent, without having authority to do so, has appointed a person to a sub-agent. He is not having authority, but he appointed a person as sub-agent. The agent towards such person in relation of principal to an agent. So that agent and sub-agent will be acting as an agent, principal and agent, and is responsible for his acts both to the principal and third persons. So I am having authority to appoint a sub-agent, but I appointed a sub-agent. Then I will be responsible to you as my principal and to others as third persons. I will be the complete responsible person because without authority, I appointed a sub-agent. And is responsible for his acts both to the principal and to third persons. The principal is not represented by or responsible for the acts of the person so employed. But the principal, I mean, if you appoint as the agent, then you won't be responsible, but I will be responsible. Nor is that person responsible to the person. So that a sub-agent will not also be responsible to me because I didn't appoint him. He is not having any privity towards me. If you are not paying him properly, he cannot come to me. He can come to you only. Or if I am this agent, I only appointed, then if they cannot come to you, they can come to me only. Section 195, where we can see the agent's duty in naming such persons. So this is what substituted agent is. In selecting such agent for his principal, an agent is bound to exercise the same amount of discretion as a man of ordinary prudence would exercise in his own case, and if he does this, he is not responsible to the principal for the acts or negligence of the agent so selected. So when you are appointing a sub-agent or when you are suggesting a sub-agent, definitely you must take care all the necessary prudence, as this is something what it is of you. It is like which on exercising his own case. Prudence of ordinary prudence will exercise in his own case. That much prudence he has to take. So what we did today, we tried to go through the creation of agency and how it is related to different actions, ratification, concept of doctrine of relation back, then who may employ agent, who act as agent, and also sub-agent and substituted agent.
അങ്ങനെ നോക്കുമ്പോൾ നമുക്കിത് മനസ്സിലാവും. See, 80 Article 80 is what about the composition of the council of composition of the council?